There it is. Okay. Here. That would be my issue. Yes. Yep. Your lives, yeah. First. Is there working right? Do you have teams on your phone? Okay, John, just shoot me a message.
All rise. Hear ye, hear ye, hear ye. The Court of Appeals of the State of Kansas.
You want to go all the way around, Judge Hurst, that's why. Good morning, everybody. You can have a seat. We are so happy to be here hearing cases this morning in Wyandotte County, my native county. For you daughters here, I grew up at 15th and Central. And we haven't, we come to KCK usually every month. We have a docket, but it's usually always at the federal courthouse. So we're really excited to be here, and Chief Judge Burns has been so amazing to help us get this. And we've kind of got this makeshift setup up here. So I hope it works out okay for all of you. But I'll officially call the morning docket of the Kansas Court of Appeals. If you will first, before I get into anything else, just let me know that you're here. The parties are here. The first is the NMB Enterprises versus English. Do we have Mr. Johnson?
Keith Rock here for the appellee.
Keith Rock, okay.
I called Mr. Johnson a couple of minutes ago and he said that they didn't get notice and he didn't realize there was arguments.
Is he coming?
He was scrambling. I literally just called him about 2 minutes ago.
Maybe we should move him down
Didn't see
the
it.
case or something. Okay, Wellpley versus the state of Kansas,
Yes, I'm Alan Johnson and I represent this.
right?
Victor Cooper at the for the state.
Okay, and are you, Mr. Cooper, are you gonna, okay, since you stood up first, I'm gonna assume that, okay. And Kinsey versus school district?
Bruce Brumley.
I'm sorry, speak up. Brumley is here. Okay, Bruce.
Fred Meatball.
Yeah, Fred, of course. Okay, good to see you all. When you've been practicing law now as long as I have, I recognize all the more seasoned faces. It's the newer people I never seem to know. Okay. I'm Karen Arnoldberger. I'm simply the presiding judge today, and all that means is I get to take time. And I'm really bad at it. So just so you'll know off the top, I often get involved in the conversation. I'll lose track of time. But if I give one side a little more time, I'll try to even it out at the end. To my right is Judge J.C. Hurst, and she's been on the court probably 4 years now.
Something like
A
this.
while. She hails from Lawrence most recently. And to my left is Judge Leslie Isherwood, who's been on within a day of when Judge Hurst came on, and she hails from Wichita. So we have a wide variety of experience here. We've read your briefs. We have, in some cases, even looked through the record in your case. So I think all the cases this morning are 15-minute argument. So, got some glasses here. So you don't need to take a lot of your time going through all the facts of your case because you only have 15 minutes and we will probably stop you to ask questions frequently. What else am I missing? After your argument, we'll take the matter under advisement, get an opinion out as quickly as possible. Oh, and right, with the appellants, I'll need to know when you step up if you want rebuttal time. So if Mr. Johnson isn't here yet, does anybody have any objection with me going with us, starting with the Whelpley case, trying to give him a chance to get here? Okay, so we will start with 129756, Whelpley versus State of Kansas and Herman Jones. And Mr. Johnson, you've entered your appearance, and Mr. Cooper and Ms. Moe, you are both here as well. So, Mr. Johnson, did you wish to reserve any time?
Yes, I'd like to reserve 5 minutes.
5 minutes. Okay, we'll see if I can do that. I didn't bring my phone out here, so I'm gonna use my watch.
Do you want to do this instead?
Yeah, sure. That's great. You're gonna set it so he gets 10 minutes to start. Johnson is aware he's supposed to be here, right? I mean, we don't need to call him, do we?
He just tried to call me. I don't even need to step out.
Oh, sure, go ahead. Yeah, let us know what the scoop is. All right, somebody real quick. Okay, you can go ahead whenever you're ready.
Thank you, Your Honor. As the court knows, because you've read the briefs, this
Yeah.
case involved in the termination of a highway patrolman by the then superintendent, Mr. Jones. I have several theories in the case, but in my limited time today, I would like to focus my attention, unless you have other questions, on the public policy tort. And that public policy tort is that it was a violation of public policy for him to be terminated for his participation as a witness at a civil service board hearing involving his subordinate, Mr. Dobler. Now, there are two aspects of this claim I want to focus on or try to explain. One of them is that I believe that there is an express public policy argument based upon KSA 752949G, which expressly protects employees who properly use that appeal process. Now, it's not clear. The district court said that that applied only to the employee who is the appellant, not to any of the witnesses. And my argument is even if that's true as a matter of express policy, that the Kansas Supreme Court has made clear in the cases I cite in my brief that public policy can be implied from statutory provisions rather than expressly stated. And that's what I contend is involved in this case. And because the public policy protects those employees who properly use the appeal process by testifying as a witness, either for or against an employee who's been disciplined. Now, those appeal procedures were discussed at some length by this court in the Hill versus State case. And in that case, this court noted that the appeal procedures were enacted by the legislature and that their integrity needs to be maintained, and that employees who are disciplined use that procedure, they should be protected from retaliation. My argument is that that's an extension of that implied public policy, is that if you are a witness who appears at an appeal proceeding, you should likewise be protected.
Make any difference if you're a voluntary witness versus a subpoenaed witness?
I don't believe so. My contention is that
on any of these issues. It
no,
doesn't make it.
because although he appeared without a subpoena, he was called by Mr. Welpley. By Mr. Dobler. He didn't voluntarily present evidence without being called by Mr. Dobler's attorney and examined and cross-examined. So the fact that he was not subpoenaed, I don't think makes any difference. He was not compelled.
Right.
Because he was under oath and he had an obligation to testify what he believed to be the truth. And what he testified was that he believed that the command or the majors were after Mr. Dobler, that it was unfair and that they were abusing their power or authority because they were firing him because he had filed or posted a Facebook supportive of some women employees of the Highway Patrol who had filed sexual harassment claims against Mr. Jones.
With regard to the implied public policy, because there is expressed public policy protecting the appellant, the person appealing. With regard to the implied, I've noticed some other statutes that where we do protect witnesses, I think workers' comp perhaps, that have those protections. An argument could be made that the legislature intentionally omitted those protections from the civil service one. What do you?
My contention is that would be more of an oversight than an omission because the purpose is the same. And the purpose is to protect witnesses who are called or who testify at a hearing. And that in particular in civil service hearings, most of the witnesses are fellow employees of the person who appeals because the issue in front of the Civil Service Board is, was the discipline that was meted out to that person a fair discipline? So the most common typical witnesses who would be called would be people who were either his supervisors or his or her fellow employees. So I don't think that that the fact that it was not included in this statute would be grounds for saying that the legislature intended that it would not. And I think the other argument can be made when they use the term employee and using the procedure that the legislature intended to include employees who use the procedure to act as a witness, is in this case to testify on behalf of a fellow employee, his subordinate, who he didn't believe was fairly terminated.
And what was the stated reason for his termination, this Wepley's termination?
Well, that gets to my second argument I want to focus on, which.
But first, answer the question. What was the stated reason for his termination?
Well, his stated reason was his testimony in front of the Civil Service Board. That was one of the.
It was
its entirety?
perjury, that it wasn't truthful. Is that?
Well, and I quoted the letter from there, and he talks about, well, there was violation of policy, but he also says, finally, he said it was your testimony in front of the Civil Service Board in which you accused the Highway Patrol of corruption.
Okay.
And so I contend that's my second point is that's
And did he appeal
evidence.
that disciplinary decision?
Mr. Dobler?
Yeah.
Yes. In fact, Mr. Coop and I had arguments in that case last month.
Okay.
Mr. Welpley did not.
Mr.
He
Welpley.
did not appeal his. He filed this lawsuit.
And what's the impact of that?
None. You're not required to. It's not mandatory that you file a civil service claim.
There's no exhaustion of administrative remedies required prior to filing a lawsuit?
No, because those are independent tort. What these claims are tort claims. And so there's no exhaustion of administrative remedies. No court has ever, Supreme Court of this court has never said that you have to exhaust your administrative remedies in those cases. And particularly the tort claim based on the First Amendment, which is governed by federal law, not by state law, there would be no exhaustion of administrative remedies.
Okay.
So the evidence, I think that the one issue that applies to all of the torts is there evidence of pretext, or is it a matter of summary judgment? Only one inference can be drawn from the evidence that he fired him because of giglio concerns. is what the argument on appeal is. Now, my contention is there's both direct evidence and circumstantial evidence of pretext. The direct evidence is what I just mentioned in the dismissal letter. Mr. Jones specifically refers to his testimony in front of the Civil Service Board and accusing the Highway Patrol of corruption. Now, the circumstantial evidence, I contend, is there are several, but the one I want to focus on is that the alleged reason for the termination, which the Highway Patrol has argued here, and I assume Mr. Cooper will argue, was that raises Giglio concerns, that his various versions of what he thought raises Giglio concerns. My contention is that it could be viewed by a reasonable jury as circumstantial evidence of retaliation because there's no evidence of the Giglio issues in the record. It's not mentioned at all in the termination letter by Mr. Jones. It's not mentioned in Mr. Jones' deposition. So there's no evidence of a Giglio problem in that case. And I think a jury could reasonably infer from that, well, that's just an excuse, a pretext to cover up the real reason.
It's a jury question.
That's exactly right.
Jury.
Jury question.
Is the time out? I don't.
I may have used up my time.
It's 1:17. No, you still have another little over a minute on your.
Okay, well, I'll just, and the one case I would point out that I think is very close to this one is the Lumry versus State, which involved the KBI. And this court reversed the district court who had similarly found on summary judgment that there's no evidence of pretext. And the court said this has to do with intent, and intent generally is a jury question when you have some kind of circumstantial evidence. So unless the court has any questions, I'll reserve my last 5 minutes.
Thank you very much. Right, Mr. Cooper. Why isn't this a jury question?
Also, because there's no evidence of pretext. That's the first one.
Okay.
First, and that's the tail end. The front end, we don't get past go.
Okay.
There's no prima facie case. There's no, so addressing first issue that Mr. Johnson addressed in terms of trying to get in the door on a public policy retaliatory discharge claim under 75-2949. Again, that applies to the participants. There are statutory, as Judge Hurst notes, there are statutory protections for participants in judicial proceedings, particularly people who respond to a subpoena, people who respond to a jury summons. Those sorts of protections apply. That is not incorporated in the statute, as noted, Mr.
But we're not protect, I mean, why would this be different?
First off, it's covered by the First Amendment and the Ruskowitz first public policy discharge claim. So I'm not saying there's no claim here. I'm saying there's not a claim under 75-2949.
No express public policy.
There's no express public policy, and there is an express public policy that was recognized by the Supreme Court in the Ruskowitz case for the exercise of First Amendment rights. It's all the same conduct that we're talking about here. Mr. Buckley is claiming to have engaged in First Amendment protected conduct by testifying at the Civil Service Board hearing. What he omits is the fact that his testimony under oath during the civil service proceeding, what he said under oath in the proceeding is directly contrary to what he said in an official writing. And he admits you cannot square what he wrote in his supervisory review of Dober's conduct during the pursuit in Topeka against what he said at the Civil Service Board hearing. One of those is not true. And the Highway Patrol did not resolve which of those is untrue. It's you admitted under oath that either what you said under oath is a lie or what you wrote in your report is a lie.
So does it matter if there were other reasons listed for the termination? Your opposing counsel mentioned that it also said because of your testimony against.
Your testimony under oath revealed that you had
That's the only
lied.
thing. Okay.
That's what that means. And what's
So let me back up for just a second. So if we get through the first issue, the retaliation issue under 2949G, and say that he wasn't the appellant, so that it doesn't apply to a witness, which is what you're saying, right?
Sure.
We don't get to the second issue. We move right to the First Amendment issue.
You wind up at the same place either place.
Right. And I think
And
you're
that's-
saying that too.
that's-
That's a claim. It's just, it's not under
That-
this, it's under the First Amendment.
Right.
And so now we look to see what was the reason, and is it a jury issue as to whether this was pretextual? Is that a factual issue?
It is not, because the first three issues under the Garcetti-Pickering analysis of the First Amendment are all questions of law. Period.
Right.
Full stop. So was his testimony pursuant to his official duties? Of course it was. He was testifying as a lieutenant of the Highway Patrol as to whether Dobler did or didn't violate KHP policies. That's pursuant to his official duties. No citizen or civilian gets to weigh in on a civil service appeal. You only get to be there if you're part of the underlying facts, which Mr. Whelpley was not, or if you're the one doing the review and weighing in on whether that conduct by Trooper Dobler at the time did or didn't violate Highway Patrol policy. That is, by definition,
Okay.
speech that owes its
Agreed.
existence to his official duties.
Okay, so then step two,
Then step two is it of a public concern? Did an individual trooper in a specific instance? And we did preserve this in the record in terms of arguing. Our briefs on summary judgment argue, and our brief on appeal argues, that as a matter of law, the state prevails on each of the three Garcetti-Pickering prongs of the first three. Well, and actually, and we preserved, the court didn't rule on, we also went on the fourth as well. Excuse me, it's actually the fifth, but with respect to the second, is it a speech on a matter of public concern? Whether Trooper Dobler did or didn't violate policy, and whether and the argument is no, that's not a public concern. That's an issue personal to both Trooper Dobler and an issue personal to Mr. Whelpley. And then on the third one, does the Highway Patrols and the state's interests outweigh those of Mr. Whelpley? Of course it does. In terms of does the Highway Patrol's interest in the efficient and effective operations of the Highway Patrol outweigh Mr. Whelpley's desire to say holding people accountable in a manner that hadn't been done before outweighs those of Mr. Whelpley?
so you're saying that the Kansas Highway Patrol's policies outweighs Whelpley's First Amendment rights?
Their interest in employing people who aren't liars outweighs Mr. Whelpley's desire to
That
say his
presumes
lies.
the fact that we believe that they terminated his employment for lying. And
There-
that, I think, is undecided.
No, there's no evidence that that's a pretext.
Different letters. There was a letter that mentioned his, talking badly about, and then the second letter said something else, right?
No, the second letter went through and enumerated how what you did, your testimony reveals that you have lied. The second letter reveals how that fits into 75-29-49 in terms of being incompetency in the performance, gross misconduct, and moral conduct.
So the fact that the letters mention other things doesn't demonstrate pretext, in
No.
your opinion.
No, because those are,
They mentioned.
they are mentioned in terms of you admitted to lying. That lying,
The talking badly about
it's not about talking badly. It's about you lied.
was another reason given, but there was also the mention of the talking badly about the Kansas Highway Patrol.
I disagree.
It wasn't? Like,
It-
actually, they didn't say that in the letter, in one of the communications.
In the letter, they don't talk about you saying that there was corruption. It's just you testified and
It was a first thing given to him.
that was the professional standards notice saying we're going to investigate the truthfulness of what you said.
Okay, so the fact that the first one has the corruption mentioned doesn't provide evidence of pretext of the.
No, that was that was the letter triggering the professional standards investigation, which revealed, all right, You said this in your written report, you said this under oath. You can't, those don't go together. One of them's a lie.
Does it matter that he contends that the written report was given under pressure? Because
First, no.
okay,
And I'll tell you,
why?
you sign your name to a report saying, and you, by statute, by rule, if you put your name on a report, it's got to be truthful. You then testified under oath, what I wrote in my report, I don't believe was truthful.
Because I thought I was gonna get in trouble if I didn't write that.
You still write the truth. If you don't like it, write what you believe. And the fact of the matter is, he does believe that Trooper Dobler violated policy. And that's what we were in front of the panel 3 weeks ago, was Trooper Dobler's appeal from his dismissing. And it's, you know, this is a larger,
Testimony though here was that he didn't believe the trooper violated policy.
what he said is, I don't have a single problem with what Trooper Dobler did. And what Trooper Dobler did was get in a pursuit
I know.
in Topeka.
That it
I
doesn't.
know you do, but what Trooper Dobler did, and I'm speaking to a broader audience.
I know,
Well,
we don't have to know either.
but no,
Not relevant here.
it is. It is because Bryce Whelpley knew that Trooper Dobler had been told, don't get in pursuits in Topeka. And he got in a pursuit in Topeka,
Right.
and he killed somebody. And then Whelpley reviewed that and says, you violated policy and discipline is warranted. And then under oath at the Civil Service Board hearing, he retracted that.
Well, he first said he didn't violate. And there was,
And he was told, take a hard look at that,
he was told, take a hard look at that.
because it's really inarguable. It is beyond dispute that Trooper Dobler in fact violated policy during that pursuit.
Whether he did or not, we're just talking about what Whelpley thought.
You sign your name to a report saying he violated policy and violated a direct order, and then come back later and say, no, I don't believe that. You can't say both of those.
And he's saying the reason of this coercion has to do with this corruption allegation, basically.
Yeah, well, his corruption allegation, as he defines it, is they didn't like Trooper Dobler. And that's the corruption they're talking about. Well, there's a reason to not like Trooper Dobler, because Trooper Dobler violates policy and kills people. So if you're okay with that, then we're not okay with you. And that's the result here. Mr. Whelpley, if you think that doesn't violate policy, you can't work here. But the reality is, and what happened and what the record shows, is that Trooper Whelpley lied, whether it's in writing or under oath. And that's nothing that we have to decide. They can't be squared. He lied.
And if lying is the issue, First Amendment, you don't have a First Amendment right to lie.
You don't have a First Amendment right. And
Yeah.
in terms of the pretext argument, where they're talking about, oh, nobody mentions Brady Giglio. We don't have to wait until the state loses a prosecution because of the Giglio issues to fire somebody who has Giglio issues. It's irresponsible to continue to maintain and employ people that we know that they lied, who are not going to be able to be presented as credible witnesses in a jury trial. And that's why Trooper Whelpley got fired. With respect to the exhaustion issue, he did file a Civil Service Board appeal, and he withdrew it the day before the hearing because he didn't want the Civil Service Board, he didn't want a tribunal to enter a finding that he's got Brady Giglio issues.
So was exhaustion required before he brought this suit? No?
Yes, because he's arguing that's not the real reason, and if it wasn't the real reason, that's something he can exhaust through the Civil Service Board. And so it would be a collateral estoppel otherwise.
There was a lack of briefing about that.
Because that was not an issue that was raised on summary judgment. The issue raised on summary judgment is you don't get past go on the prima facie case of a First Amendment claim. You don't get past go on a public policy under 2949. And even if you do get past go, there's no evidence of pretext. And those are all bases that the district court relied on in granting summary judgment.
Do we have to get to pretext if we decide that the state's interests outweigh his?
You do not.
Great.
What I believe the district court was doing was being belt and suspenders, sure, and disposing of the case. So it's like, even if it's arguable that you get past go on a First Amendment claim, or even if it's arguable you get past go on a public policy tort under 2949, you're not going to make it past pretext. For all of those reasons, the district court's grant of summary judgment should be affirmed.
You have a little more time, but we do not penalize you for stopping early.
Well, I'm looking,
The questions.
Judge Hurst has a quizzical look on her face. So I'm waiting, seeing if she's got another question. Otherwise, that was a good wrap.
I'm okay. I am troubled that the first communication mentioned something that the second communication didn't mention.
Yeah, but and my response to that is the reason given in the second communication is still true and not evidence of pretext. And again, the first communication was the professional standards notification of, you said these things in your hearing. We're going to investigate you for the truthfulness.
And more, it said more. It said you badmouthed us. You talked bad about it.
And what's your basis for saying corruption? And when you drill down into it, he's like, you didn't like Dobler. Okay, but that's not corruption.
Well, corruption can be lots of different things. I mean, we don't have briefing here on what corruption is, because you ultimately, he wasn't terminated for that, right?
That's right. He was terminated for lying.
Okay.
Thank you very much. Rebuttal, please. So what gets you a jury trial on the First Amendment issue?
Well, I believe that all of the first three steps of that analysis are all a matter of law. But the most important one is the third one, which is the balancing of the interest of the highway patrol against his interest. And I think the most significant case involving that is the Lytle case, which they cite. It involves the city of Wichita. He was an officer of the city of Wichita, and he accused.
Which one was that?
Lytle versus, it's a 10th Circuit case.
Okay, got it.
And very similar to this, he accused the
Lytle.
Department of abuse, corruption. And the court in that case found that the interest of the employer outweighed his interest. But specifically because there was testimony there that free speech interfered with his relationship with other officers. The police chief testified in that case that had that effect. That's different in this case because there's no testimony in this case by anyone that Mr. Wellplate lied. Mr. Jones does not say that in his termination letter. He does not say that in his deposition at all. There's no evidence. Giglio is not mentioned in any part of the record itself. It's mentioned in their brief, which I contend is evidence of pretext, so that there's no evidence to support the idea of Giglio. If you go back and read what Mr. Jones.
You're saying they have to mention Giglio? I mean,
if that's your basis for firing somebody.
But I mean, isn't that kind of, everybody knows what Giglio means? You can't have an officer that's lying.
Well, that was the issue.
I'm just, are you saying those magic words needed to be said?
Yes, if that was the basis for that. And I go back to the Lemery case. In the Lemery case, the KBI expressly said, hey, you got Giglio problems. And this court said, well, whether that was your true intent or cover up for retaliatory intent, it's a fact question for the jury to raise. Now, I want to address the issue of exhaustion because it wasn't raised below. In the context of a 1983 claim, I didn't cite it because the case hadn't been decided, but there's a case called Prager versus State, which I think is either 271 Kansas 1 or 270 Kansas 1. It involved an appeal through the civil service. Mr. Prager was an employee of the Department of Revenue. He appealed his civil service case and combined it with a 1983 case. And the district court said, well, there was an exhaustion of remedies required. He couldn't bring his 1983 claim, and the Kansas Supreme Court said, no, 1983 is a federal claim, and under the federal law, there is no exhaustion. But the thing I want to point out is that if you carefully read Mr. Jones's first letter, when he explains to him why he's firing him, he says, when questioned about this apparent contradiction between your sworn testimony and the statements you made in your official reports. That's important because he's only talking about an inconsistency, a contradiction. He never says he's lying. And I want to point out that he was no different than Captain Witham. Captain Witham had various versions of what he felt, and they both, in their very first report, said, we find he did nothing. Now, Witham, after he'd been schooled by the majors, when it comes time to testify to the Civil Service Board, he says, well, now I find that there was, and he had lots of reasons for that. But there is a contradiction between, again, what Mr. Witham testified at the Civil Service Board versus what he first said.
Are you using that example to say because they treated another employee differently, it was pretextual just for
Yes.
well played? That's what
Right.
you're using that.
Treating similarly situated employees in different ways is a way of showing pretext. Mr. Witham, Captain Witham, still works for them.
You don't think there's a difference between those two though? Because at Witham's testimony, he didn't end up contradicting.
Well, he contradicted his first two. He had various versions of his reports. His very first report is just like Mr. Wellpley. We don't see anything wrong with
But
it.
then he amended that or changed it or whatever. So
Right.
then his testimony ended up matching his final.
His
Right.
final one, but not his first two. And that's why I'm saying that, and that to me raises whether or not they are similarly situated employees. That's a fact question for a jury to determine. Are they in fact similarly situated? And if they are, is the treatment of one different than the other circumstantial evidence of retaliation? And in that same letter, he also says that after he says there's this apparent contradiction, he says, you responded at the hearing by stating you were doing the right thing by testifying about the corruption of the highway patrol. So he clearly, Mr. Jones himself, in writing that initial letter, here are the reasons why I'm firing you. He references not only his testimony and the contradiction, but the fact that he was accusing the highway patrol and Mr. Jones of corruption. And as I point out in my briefs, that accusing public employees or employers of corruption, it has a high place on the First Amendment totem pole of what those interests are. Unless the court has any questions, I've probably already used up my 5 minutes.
Oh, thank you very much.
Thank you.
Excellent arguments from both of you. Great briefing. We always appreciate that. And it's going to be a difficult issue to decide, but we will get you a decision. Thank you very much. I still see that Mr. Rock is out there. Maybe they're having settlement negotiations or something on the first case. So if Mr. Brumley and Mr. Greenbaum, if you're ready to move forward on your case, we'll continue to let Mr. Brock talk. It could settle out there in the hallway.
Watching what we did to Cooper and
Our case won't be nearly as interesting.
Do you, just a second, do you have any updates, Mr. Brock?
Then I said it here, said ETA shows 11:30.
Iola.
Okay,
Oh, Lord.
all right.
Right.
We'll leave this door ajar, it's locked from the outside.
Oh, you couldn't get back in. We
Oh,
thought
sure.
that you guys had settled out in the hall. We were convinced of that. Okay, do you mind waiting around for him? Or are you gonna?
Yeah, I'll do whatever the court wants to do.
Okay, you know, it's gonna push us a little bit, but we'll try to see if we can accommodate that. Okay? All right, now we have Kinsey versus Unified School District, and Mr. Brumley, did you wish to have rebuttal time?
5 minutes.
5 minutes, okay.
My argument isn't going to be as extensive as what you just heard.
Right, this is a workers' comp case. We've read that.
I mean, different issues,
Different
right?
issues. Does evidence?
Just got boring old substantial evidence here.
All right,
Just as important.
We'll take it.
it's just important.
Certainly is to Tony, so.
You know, that's really the great thing about being a judge or an attorney at all. You get to be, have a different case on a different topic every minute. And so go ahead.
Okay. All right, your honors, my case is pretty simple. What I argued in my brief pretty much states it all. The substantial evidence we feel it was ignored below was the fact that my client still has symptoms. She had symptoms through the regular hearing and they continue through today. The court found essentially, and it was affirmed by the board, that this was an exacerbation or a temporary accident that went away. But both doctors noted the continuation of symptoms. So under substantial evidence, and there's two cases that I think.
Both doctors testify there was no permanent damage, though.
Dr. Shapiro did.
Respiratory.
Dr. Zimmerman found a rating.
Okay.
I shouldn't know what it is, but I know there was a rating and it's in there and I'm sure it's somewhere.
I'm sorry to interrupt.
Oh, no.
There's a fan back here and it's hard for me to hear.
Oh,
You wouldn't mind
I'll try.
hollering at it.
I like the microphones. I speak soft.
I know, I'm sorry.
That's all right. Did you hear the part about the
There's a rating, yeah.
rating?
Yeah, one did a rating, the
So-
other one said no permanent,
The issuance of a rating by itself shows.
shows the permanency, right?
Or you couldn't rate them.
Right.
And that gets to the second part of my argument under Johnson versus US Foods.
Mhm.
But first, I want to talk about the standard of review under substantial evidence. Admittedly, it would be better if it was purely a legal question for me. I understand substantial evidence. But if you look at Pereira versus Gallegos, and which is a state case, and it's also, I think, kind of codified in the review statute. And you have Richardson versus, I don't have my glasses, Perles, which is a United States Supreme Court case, which basically says, in a nutshell, substantial evidence. Hear me okay?
Yeah,
Trying.
sorry.
Yeah,
Sorry, yes,
all
I
right.
can. It's better now. Thank
Yeah,
you.
good. Substantial evidence is any evidence that a reasonable person would accept to justify the decisions below.
Mhm.
The fact finding which we're looking at is twofold. The existence of symptoms which still continue and competent evidence under the Johnson versus US Foods case.
But don't you need, I mean, you have substantial competent evidence of the symptoms,
Yes,
but the greater concern is the cause. And so the cause,
the cause, yes.
so isn't that what we need the substantial competent evidence of?
Yeah,
Okay, but we don't have that. You're telling us that there's substantial competent evidence because she had the symptoms. But where is the substantial competent evidence that those symptoms are a product of her injury?
well, it's twofold, maybe threefold. Dr. Shapiro said it was a temporary worsening. The claimant testified and said, I didn't have them before, which I think is significant. It's competent evidence. And I think it's substantial evidence. I mean, it's just simple temporal time relationship. She didn't have the symptoms before the exposure to the chemicals.
But doesn't Dr. Shapiro also say that her explanation of the symptoms does not match anything that he tested for with the CT scan, with the scope? There's no indication physically.
I don't know that he specifically called her a liar.
I'm not saying that. I'm just saying that there was some indication in the record from Dr. Shapiro that those two don't match.
He may have said the objective tests, and I think that's what you're getting at.
Yes.
Didn't explain. I don't know that he was saying they didn't exist.
No, that's not what I'm saying. I'm just saying that they don't jive, that whatever his tests were,
Oh,
they were testing for, does not square with the symptoms that she's explaining.
The objective test didn't support it. That's right.
Yes.
That's basically what he was saying. But I don't know that he said it so specifically, this wasn't from the accident. He said it wasn't prevailing factor, I think, which is the standard in the statute. But the statute also says the ALJ is the ultimate determination, the one who ultimately determines prevailing factor. And that's where I think the claimant's testimony is relevant. She didn't have the problems before the exposure. She had them immediately after, including feeling nauseous and some pretty drastic symptoms, which were triggered, which is not enough to be covered by the act, right after it happened. So, I mean, the facts, without, you just took the medical evidence and went, they're experts, throw them away, and just looked at the facts of the case, the temporal time frame supports prevailing factor that something happened when she was exposed, you see. And, part of that reasonableness standard, I believe, of course, I'm arguing against it here, the findings is that you have to explain why you reject testimony. Dr. Shapiro's medical evidence reports were relatively scant. His testimony was quick. I think he had a procedure or something. If you read the depo, it's there's not a lot of explanation other than, yeah, the scans don't support it. That's there. That's true. But then you look at the testimony of the claimant, and you look at Dr. Zimmerman. I really don't want to get into a fact question, but his report's quite detailed. His testimony was quite detailed. The judge is required to explain their decisions under substantial evidence. And it's like, okay, well, why did you reject the claimant's testimony? I think even somewhere the judge found her credible too. So if she was credible, well, why not listen to her testimony of like, hey, I was A-okay before this, and now I'm coughing up clear fluid.
Do you think that the ALJ explained why they discounted Zimmerman's testimony?
From memory, I'll just tell you what I think happened. Dr. Shapiro is an ear, nose, and throat doctor, and Dr. Zimmerman is an expert that claimants frequently use. And I think that's.
And he is not an EMT or
What's his,
He's
the allergist?
internal medicine.
just internal?
I think that was what he went with. I don't believe he said that word for word in his decision, but maybe it's implied. Dr. Shapiro is an EMT. I understand that that's probably more on point. Unfortunately,
Isn't the treating physician usually also given some sort of?
not really. No. No,
So substantial competent evidence
yes,
is the standard.
absolutely.
And it's tough to be an ALJ or a board member. They've got to listen to two conflicting views,
Uh-huh.
to make a decision. And we don't substitute our judgment for their judgment.
Right.
You've got a big
I know.
hurdle here.
I was sitting here watching the argument before. I'm going, oh, I should have waived argument.
No, we like to hear them.
Yeah,
We like to hear
uh-huh.
them.
Yeah. But really, the only,
Because every workers' comp case, you're gonna have conflicting doctors. And they have to make a decision based.
experts.
And are you saying the ALJ, which was supported by the board, didn't sufficiently explain the reasons for the decision? Is that?
I'm saying that, and I'm saying they ignored. They didn't explain why a lady without symptoms doesn't have permanency. And I'm using
Well, it goes back to Judge Isherwood's question about causation. I mean,
prevailing
I
factor.
don't remember my Latin term. Is it res ipsa locator that is because of this, it must be this? That's kind of what her argument is. Because I had this chemical exposure,
Yeah, that's true.
then that's,
Yeah, that's a big part of it,
but that's why we bring in medical experts to say, okay, are the subjective symptoms consistent with the objective evidence? Right?
Yeah, that's true. And I think what you see a lot also, just to be blunt, is you'll get numerous experts saying different things depending on who hires.
I know, and both sides are hiring their, I mean, it's all a
So I guess
game.
at this just kind of popped in my head with all of your questions quite good. Well, if you have two experts, and couldn't the deal breaker be a credible injured party, you know?
Uh-huh.
And so simply, in a nutshell, the competent evidence that I think was ignored or not explained, either one, it's also relatively undisputed that their symptoms, I don't think anything disputes it.
Right,
Their symptoms started at the accident.
right.
And then when you get, and the judge did find an accident, by the way, he did find an accident.
Mm-hmm,
He just said it was an exacerbation, which is excluded from permanency.
uh-huh, right.
And is that my warning?
I don't do a warning, but yes, that's your warning.
Okay. Well, just in closing, under Johnson
You'll
versus,
still have your rebuttal time, but go on.
under Johnson versus US Foods,
Mm-hmm,
the judge doesn't just look at the AMA guidelines.
right.
They also look at,
Competent evidence.
and my competent evidence is, hey, permanency means it's still happening.
Uh-huh. Okay,
That's my argument.
thank you very
Thank you,
much.
guys.
I get it. Green bomb.
Well, this has been a great morning. It's very interesting.
Uh-huh. Kinds of case.
All kinds of things. Well, and they,
Missing the oil and gas.
The oil and gas one's very-
Case.
oh, wow, well, that's really up,
Lots of numbers.
that's really in our wheelhouse. 15th and Central is more interesting than about
So
anything.
you're familiar with it?
Oh, yeah, well, 7th in Minnesota for 35 years.
Oh, yeah.
You know, so,
Oh, yeah.
yeah, yeah.
I'll just as an aside, when my brother and I came back to visit our old stomping grounds and we entered the neighborhood and it said, you are entering the historic Prescott neighborhood. What?
Wow, who knew?
Didn't seem, was it historic because we were there?
Yes.
By Bethany, right?
Well, what's further, we're down from Bethany.
You're a little bit
Closer to 18th
in
and
the west.
Yeah.
Oh, yeah, 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 yeah. Yeah, well, it's, you know, and
We
it,
used to walk to there was a park at Bethany. We
right,
used to walk-
right. I used to play tennis over there.
Yeah. Okay.
Yeah.
All right.
Okay, here we go.
Home stuff.
Okay, yes. I think this is a fairly straightforward matter as you identified, and I think there is clearly substantial competent evidence to support the decisions of both the board and Judge Hirsch. In response to some of the questions that you asked, Judge Hirsch did specifically state in his award that Dr. Shapiro is an ear, nose, and throat specialist. He's a surgeon, board certified ENT, practicing in that area for a long time. Dr. Zimmerman, on the other hand, does really not practice anymore. He's primarily is involved in medical legal matters, and that, you know, on my cross-examination, as always, I go through some of that as
Mhm.
his, you know, background and what he's done. And so it's in there, and Judge Hirsch did specifically find Dr. Shapiro more credible. One thing I'll explain how we got to Dr. Shapiro is we went through the preliminary hearing process. And so I was ordered to provide the names of two physicians to evaluate and treat if necessary, Ms. Kinsey. And so Dr. Shapiro was one of the choices. I think he was the most available, so Mr. Brumley selected him, and that's how we got into his being the treater. It was through court order. And as you've noted, he did the diagnostic laryngoscopy, he did the CT scan, everything was normal. We're in a case where, you know, she is using a cleaning product that's used in a school, so it's with, you know, children. And so this is what she claims has created the symptoms. And of course, you know, we're in a position where, you know, disproving that is pretty much impossible as far as, well, look,
There's no reason to suggest that she's not telling the truth. I
Right.
mean, of course, I'm sure.
yeah, she's doing the cleaning, she has symptoms. It's like, okay, you have a reaction to this. That's fine.
And that
Let's,
she's gone through a lot. Nobody just does that just for the sake of.
right, and let's go and do what we need to do, which is what happened.
Out.
Yeah, and then, fortunately, and even if you read Zimmerman's report, the findings are, there aren't any findings. There's nothing objective, in his report. It's pretty well, Ms. Kinsey says, I've got these problems, and then, Dr. Shapiro does his testing and, just finds that there's no permanent impairment of function based on everything that I see here.
The objective.
Yeah, and so he says, look, if she has anything, then she has whatever a personal issue, but it isn't, I can't link this. I think that was a lot of
Causation.
yeah, that's what Judge Isherwood explained, that, I'm not seeing the link up, I'm not seeing the causation, and there isn't. It's pretty, you've got to, well, we can't find anything, and you have complaints, but I can't see any link up between your ongoing complaints and whatever, being around the, whatever cleaner this was. So I think it's,
No testimony that something like this can result in can trigger a lifelong issue with this, that,
no, and, I think it's,
because, sometimes it seems like you'll get something and you've never had it, and then all of a sudden you have it forever because it triggered some mysterious thing. I mean, yeah, that's the extent of my medical knowledge.
well, and I get, as you would expect through the years, I've had different, types of cases that involve these kinds of issues. And they're hard cases, especially from, Bruce's end. They're really hard to prove because you just, unless you find something that's sort of a known factor, and then the cases that really cause you concern and that you end up,
Like
doing a lot of
I mean,
treatment.
they talk about.
Yeah, I have plenty of those.
Right.
And, I get the link up and then I get the findings though. On all of those, like all my COVID cases, there still are significant deficits, with the people I've got mostly in Missouri actually now. I don't have many Kansas COVID, fortunately. But in Missouri I do. And I've got some that are bad. I mean, where the pulmonary functions.
Was there any evidence presented in this case of pre-existing asthma? No pre-existing problem?
No, nothing that we found. And we're really, again, relying on Ms. Kinsey's testimony.
Right.
She said, no, I haven't had anything. I used this cleaner and then I started having symptoms. And so we went from there. So, but fortunately, there aren't any objective findings. So, that's a good thing that even Dr. Zimmerman,
That there's no longer been
did-
damage?
yeah, so, this is one of those where, again, I think they tended to lean toward the causation because of her testimony. But in terms of actually linking up whatever she used, which was never really, sought out in detail, it's just a, cleaner that's used in the school. And whether that created the problem, who knows? I mean, and I get, it's interesting. I hate to digress, but this is the interesting part of this, is I have a number of school cases where employees do have reactions. I've got one now, I got a call yesterday where the lady is just allergic to certain perfumes. And so it's like, well,
Was there any testimony here? This was just an allergic reaction?
well, I think there's sort of a underlying question in that way, because Shapiro says, what she's got is personal, and so.
So she's having these symptoms and it could have started after this chemical exposure, but there's no way for anyone to say that it did.
I mean, it's
The issue.
yeah.
There's no reason, there's no way to say that this chemical exposure causes these symptoms forever.
But this doesn't, if we were to buy into this argument, right? this doesn't clear all of her hurdles, because then the long-term treatment, which is the Flonase, she doesn't qualify under that. So if she clears this hurdle, she's stopped under that one.
Yeah, because Flonase is over the counter and you get over the counter and work comp under, 515. So,
Well, it's frustrating. I'm sure she's extremely frustrated.
well, work comp doesn't cover everything.
So can we go to, though, the argument that there is a little bit of argument here that the board didn't explain their findings, and you're saying that the judge did explain that they found the ENT more credible, and this is why
Yep.
he discounted the other
He
testimony.
absolutely did.
Okay.
He absolutely did. I mean, that really was his bottom line.
Okay.
Thank you. You've got your 5 minutes of rebuttal, Mr. Brumley.
I'd say I wouldn't use the 5 minutes, but I always talk longer.
What?
I always talk longer. Kind of want to do this in reverse order. This is in response to Judge Wood. You talked about the Flonase. There's 2 issues, just to be clear, in terms of permanency. Future medical, which is clearly what that goes to, and then functional impairment, which is the award of disability. They're 2 separate issues in terms of permanency. And on permanency, that's the big argument with the competent evidence that I'm referring to. She still has the symptoms. And the personal risk, personal condition argument it'd be a strong argument if the accident was on Monday and then 3 Mondays later, the symptoms came about. But the symptoms came immediate, same day, and worse at first. On that, I'm going to kind of jump to the first thing that came up that I wrote down. The cleaning product, if I remember correctly, and I'm pretty sure I'm right, it's most likely in my brief, definitely in the record, it was a mixture. It wasn't just one cleaning product. So when mixtures are combined,
One of them was bleach, right?
yeah, bleach is a common thing that can cause problems. I remember when we had some mold, my bleach guy was wearing a mask and kinds of stuff. And I'm like, why? I'm working with bleach. Well, it was mixed with something and that caused the problem. So it just wasn't a spray on clean thing. It was a big thing. And then
Was that mixing standard usage in her job, or do we even get to that?
well, yeah, she was cleaning.
No, but I mean, this mixing of chemicals is something they did
I think so.
commonly and,
Yeah, I don't know that it was an issue really. So I would assume.
okay.
Yeah.
Yeah, I just didn't know if there was anything related to that.
I don't think she did anything out of the course of her employment. That wasn't an issue below. And I want to talk a little bit about Dr. Zimmerman. He used to treat, he's an elderly gentleman, probably closing in on 80, which is a lot closer now. I'm 61. When I was doing it, he seemed really old, but doesn't seem so old now. He does a lot of causation reports. So if we're looking at experts to justify substantial evidence, Dr. Shapiro is more, and there was a question about, can't remember which judge asked me about, do treaters get more weight? I think the answer is they weigh them the same, but treaters often or less often deal with causation issues. They want to treat. Surgeons want to cut. They don't want to deal with me. They hate, they'll play golf with me, but they don't want to talk causation. Dr. Zimmerman does causation, and this isn't in his depo. It's my standard questioning of him. He is primary plaintiffs and claimants in personal injury and work comp, but he also worked for the Department of Labor, for the feds. He did causation somewhat on the other side for the federal department. So he knows how to address causation. And I think I may have asked him, I don't remember. The time relationship was a big deal. You know, it's other competent evidence that justified this impairment. That's my pass. Hopefully someone catches it.
Right, right. I get it.
All right. Thank you, judges.
Thank you very much. Okay, we are going to stand in recess right now and we will be back in here at 11:30. If he gets here, that was his ETA on his Google map or whatever. So unless he speeds like a demon, that's gonna be,
And you can still take this far.
oh, move him till the afternoon.
I always.
Would you think,
drive it.
Mr. Brumley, if we moved it to 1:30?
I would be fine with that, because even if he gets there at 11:30, he still has to park and get through.
Right, why would you mind relaying that to him? That we'll go ahead and put him first on the docket at 1:30 is when we come back, right?
Does that work for your schedule?
I mean, that is very nice of you to accommodate that, but that way it'll give him a little time to kind of get his bearings and for you guys to talk settlement, maybe. Okay. All right.
Thank you.
Thank you very much. Now, rather than push that lunch, that's a better idea, because I think we only have 2 this afternoon. Anyway,
I
okay.
don't know. It's just.
Oh, well.
You can make it stop. Okay, we're in recess.